Welcome once again to Lehto's Law. Here's Steve Lehto.
Several people sent me an interesting story out of Florida, and it's a topic we talk about quite a bit on this channel, and that is, when can you record the police? When can you record the police, like say with some kind of video device, smartphone or otherwise? And there is a strong belief among most people that you should be allowed to record them anytime they're out in public doing their job, so long as you can record them without, trespassing or something of that nature. But if you're out in public and you see the police officers over there doing their job, you should be allowed to pull out your camera and videotape them or film them or whatever it is that you want to do. And that's what many people want to be true. I've pointed out that the law is not as clear as people would like. And so I'm a lawyer. My job is not to tell you just what I believe ought to be the case, but I try to tell you what is the case. So this story is very important because recording a cop in Florida could get you arrested. And a court of appeals in Florida has said that is legal in Florida. So let's follow along here. From TampaBay.com, Mark Freeman wrote the story for the South Florida Sun-Sentinel. Now, here's the deal. A Florida appeals court ruled recently that the arrest of a woman who filmed officers outside a movie theater was a good arrest. And there's several different ways these stories can play out. And what happened here was the woman got arrested because she was filming the police interacting with her son. They arrested her. Later on, the charges got dropped, so she filed a lawsuit against the police for arresting her. That lawsuit got thrown out of court. That's what she took up to the Court of Appeals, and the Court of Appeals said, no, your lawsuit should have gotten thrown out. The arrest was good. So again, I'm not saying I agree with the reasoning. I am merely the messenger here, okay? Officers had the authority to arrest a young mother who recorded them detaining her teenage son in 2009. This happened a while ago. This is how long it takes stuff to get its way through the system. This was a 2-to-1 opinion by an appeals court panel in Florida. That's the 4th District Court of Appeal in Florida. So 2-to-1, meaning that 2 judges said, yep, good arrest. 1 judge said, no, it's a bad arrest. But it's a majority rule, 2-to-1. In the short, the judges wrote, she obstructed their investigation and processing of her son's detention, a lawful execution of their duty. The judges in the court said that she was interfering, she obstructed the investigation. So that's what they wrote. Now, the woman, in sworn testimony, said that she brought her digital camera with her to pick up her son, hoping it would prevent the police from lying about what happened that night. And so it actually was a digital camera because this was 2009. So she said, I thought if I had the camera, everyone would be honest and truthful. So again, we all understand the thought process here. It, however, turned into a confrontation in the parking lot. Officers said they gave repeated orders for her to stop using the camera without their permission, as it was interfering with the investigation of the teen accused of sneaking into a theater. So the police said, look, we're investigating a claim. Someone said this kid snuck into the theater. Mom shows up with the camera. And now, we don't know the exact amount of interaction here. And that's one of the issues. I wasn't there. I don't suppose you were there either. But they said it was interfering with their ability to do their jobs. Lawyers for the officers argued that not only did she obstruct justice without violence, was one of the charges against her, but she was invading their privacy by intercepting oral communications. And I've mentioned before in other videos, one of the things that most people have a problem with on a video I did, I talked about how you can, in some states, be accused of eavesdropping if you record someone's conversation out in public. And people say, oh, Steve, there's no expectation of privacy out in public. There's no expectation. Well, some states have got eavesdropping laws that say that you cannot record the conversation of somebody else without their permission. In some states, depends on the state. So they said there's 2 points here. One is she was recording the conversation without their permission. And 2, she was obstructing what they were doing. So again, that's the argument. The appellate court judges in the majority did not comment on the issues about the video recording, aside from noting that they had watched it. So they said, we have watched it. They noted only that the police had probable cause to arrest the woman on the obstruction charge. So you have to understand that she got arrested and the charges got dropped. The fact that the charges got dropped does not mean the arrest was not warranted. You can arrest somebody if you have probable cause. If there's not enough to proceed with a trial, then the charges can get dropped. But the probable cause is a lower standard. Now, the judge who wrote the dissent, which was lengthy, wrote that the mom did nothing wrong and police should have no reasonable expectation of privacy in public places. So that would do away with the eavesdropping argument. It would not do away with the obstruction of justice argument. But she says that the police have no reasonable expectation. So I'm not sure what Florida's eavesdropping statute is, if they've got one. And the question is, do they have an exemption for police? The judge warned that shielding cops from view would mean everyone who pulls out a cell phone to record an interaction with police, whether as a bystander, a witness, or a suspect, is committing a crime. And of course, the judge is using hyperbole there because that's not what they're saying. Obviously, if someone's 100 yards away filming, it's different than someone who's standing right here and filming. And there's a spectrum in between, right? So the judge went further as she declined to join the ruling that favored the Boynton Beach police. She said, given how important cell phone videos have been for police accountability across the nation, I do not believe that society is ready to recognize that the recording of those interactions, which include audio recordings, are somehow subject to the officer's right of privacy, she explained. And again, she's addressing one of the two arguments here. Two arguments. One is that they were recording the conversation. The second is that they were obstructing justice. That is, the woman with the video camera, or the digital camera. Some federal courts across the country have found the public has a constitutional right to record cops. The general rule, when they find it, is that recordings are allowed as long as it doesn't interfere with police doing their jobs. So again, we get down to, is the person with the camera interfering with what's going on? The federal appeals court, whose jurisdiction includes Florida, has ruled that people have a First Amendment right, subject to reasonable time, manner, and place restrictions, to photograph or videotape police conduct. So it's not limitless. It is subject to reasonable time, manner, and place restrictions. So the state attorney's office declined to prosecute the woman, but she sued the cops in a false arrest claim. The litigation continued for over a decade as a trial court judge agreed with the officers, and then, of course, the woman appealed. Now, her attorney said that he's disappointed with the outcome, and they are currently considering their next steps, presumably which would be take this to the Florida Supreme Court. Meanwhile, he wrote, we agree with the judge's strong dissent that under the well-established law in Florida, there was no probable cause for arrest. That judge who dissented concluded that the woman should not have been charged with obstruction because she did not get in the way of the officers doing their job. She did not stand between her child and the officers so as to physically impede their duties. She merely passionately expressed herself as any mother might do. Now, here's the question. If she's simply filming, how is she passionately expressing herself? And that, I suspect, is what's going on here. There's a debate about whether she's merely standing there filming, or she's standing there filming and arguing, or is she standing there filming and trying to insert herself in here? Now, this dissenting opinion said she did not do that. But that's one person's opinion of the three who watched the video and made the ruling on this case. The dissenting judge said the case is a reminder of why it's important for people to record cops in public. The facts of this case seem to be only too similar to so many police encounters caught on video or cell phones, she wrote. Given the prevalence of small video cameras and cell phones in public spaces, society has definitively come down on the side of approving the videoing of officers in the performance of their duties as a method of accountability. And again, I generally agree with the idea that if you're walking down the street and you see something happening with the police, that you should be allowed to pull your camera out and film it. You should be allowed to do that, okay? But I've pointed out that while many courts of appeal, federal, have ruled on this, some have not. In the circuits that they have not ruled, it's not settled law. The Supreme Court could rule on this, and if they did in fact rule on this, they could solve this problem once and for all for the nation with respect to the general principle. But then we get to when you see something happening and you start filming it, are you getting yourself involved or are you simply standing back and filming it? And if you're standing back and filming it, I think personally you should be allowed to film that all day long. You should be allowed to. But obviously, if there's something going on over here and you walk up and insert yourself into it, start asking questions, start telling people what to do, then the police have the right to say, excuse me, step back. If you don't step back, I'm going to have to arrest you, okay? Back off. So step back, continue filming. But as noted, Here's a woman who says that she showed up, brought a camera just because she thought that would keep things on the up and up, and filmed the police interacting with her son. And they say that she interfered. She didn't just film, she interfered. And that is really the issue here. So some of the allegations here, though, were that this went from a mere filming into a confrontation. And that's an actual word used in the story. It turned into a confrontation in the parking lot. So it's one thing if I'm standing back and filming passively, and another if I walk up and stick the camera in your face and start confronting you, okay? And so that would be an issue. So what would need to happen is there'd need to be a hearing for a court to determine what the actual interaction was. And it was simply passive from a distance, then I believe that's allowable by law. If she walked up and got confrontational about it, that might not be a protected form of recording in public. Be that as it may, procedurally from here, I suspect these people could appeal this to the Florida Supreme Court. If they get shot down there, they might be able to pursue it in the federal courts. Depends on how this case is being postured and so on. But the interesting thing is that this happened in Florida, and Florida is in a circuit that has ruled that you are allowed to record the police, except with some restrictions on time, place, and manner. And one of the restrictions obviously is that you cannot get in and insert yourself into what you are recording and say, well, I'm recording, therefore I can do this. Okay? The presence of a camera does not give you rights above and beyond whatever else you might have in that particular situation. So it's an interesting story. I suspect we haven't heard the end of it, but since it started in 2009, we might not hear the end for a long, long time. But as of right now, a woman was arrested in Florida for recording the police. The charges were dropped. She filed a lawsuit for false arrest. The lawsuit was thrown out, and a court of appeals upheld the throwing out of the lawsuit. So there you go. Ed, Donald, Jamie, and Keith all sent it. Thanks a lot. TampaBay.com published it and is written by Mark Freeman of the South Florida Sun-Sentinel. Recording a cop in Florida, one woman got arrested for it. Questions or comments, put them below. Let's talk to you later. Bye-bye.
Thank you for watching Lehto's Law. My nephew tried to stick a penny into a plug. Whoever said a penny doesn't go far didn't see him shoot across the floor. I told him he was grounded.